My name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about the Espionage Act of 1917. So in the news recently, there has been a development as a result of a raid of sorts that happened on President Trump's Florida residence. And as a result of that, there's been controversy about the reason for that particular raid. And as a result of that, the Justice Department, I believe, declassified or unsealed the warrant in terms of giving more detail about what was being sought and the reasons for that. So one eye-opening bit of information that was on that unsealed warrant was related to the Espionage Act of 1917. So I thought I'd explain a bit about the Espionage Act and why it's really important. So in terms of privacy, governments have rights around data or information related to government and national security that supersede the rights of an individual, including a president. So the Espionage Act of 1917 was passed and put into law during the President Wilson administration. World War I had started. The genesis of this act was around espionage and spying. So basically, it was to deter or punish people who possibly had information that may help our enemies in a wartime situation. So information about our national security or something to do with our commerce in some way. Over the decades, the act has expanded somewhat. So instead of just being something that applies to the military, it has been more commonly in the recent decades applied to maybe classified documents and who has possession of those documents. So at a high level in the government, and this is an oversimplification, think of sort of three categories of classified documents that may come into play here. So maybe top secret documents, and confidential documents. There are subcategories within those classifications around who can see what and when. Some of those classifications mean that maybe even a limited number of people, a more limited number of people may have access. So for example, let's say someone has a security clearance with the government for top secret. That means that some of those subcategories they may not even be able to see. This is a big deal. Part of this is not only who can see what documents, but where those documents may reside. So there may be rules around where those documents can be seen. Those documents may not be eligible to be taken into certain locations because certain locations may not have the right or proper security. Also, probably in the most recent past, I think, even though we're talking about a law that's over 100 years old, probably two cases that have come up in the news in the last several years people will probably be more familiar with will be the WikiLeaks Julian Assange case and the Edward Snowden case. So both of those, the Espionage Act was implicated because of the unauthorized distribution of classified information. Leaking information and giving information that's classified to the press and journalists, that's a big issue. This is a felony. It has penalties as well. I think from some jail time to a lot of jail time. In the 50s, a couple was executed, in fact, convicted of conspiring to give data or information to the Russians around kind of military secrets. So the Espionage Act is a big deal. The fact that it showed up in this particular warrant is eye-opening for a lot of people, and still there's a lot of scope there in terms of what that could possibly mean. But I think as we're, privacy professionals, for example, the Edward Snowden revelations that occurred as a result of, this Espionage Act case was one of the impetuses behind the invalidation of the Privacy Shield and the Safe Harbor framework, of which the U.S. and the EU do not yet have a solid agreement in place as a replacement for those things. So it remains to be seen what's going to happen with this. I thought it was a good idea to explain to people what this actually means and why it's important. That's it. Thank you.